Hello and welcome to this video about duress. This video is primarily aimed at the AQA A-level law specification. So there are two forms of duress: duress by threats and duress of circumstances. And duress by threats has been around for hundreds of years really, but duress of circumstances is a more recent development that's come really from cases in the 1980s. The same principles apply to both. So a duress by threats is if you are told if you don't do this, then something bad will happen to you. And that is dealt with by the two-part test in Graham. And duress of circumstances is because of the situation you find yourself in that you have to commit a crime. And that's dealt with by the two-part test in Martin. The classic example of that is committing a speeding offence, say whilst you're driving someone to the hospital in an emergency. Because of the situation you find yourself in, you commit a crime. So it's likely that depending on the type of question, you may have to deal with an offence first. And so you should deal with the offence in full, the AR and MR, before you go on to deal with the defence at the end. Duress is a necessity defence like self-defence. So the defendant will have committed the AR and MR, but would be claiming that their act was not voluntary because of the pressure that they'd been put under. So in relation to questions, you need to introduce the defence. It's a common law defence, primarily dealt with by precedent and case law. And you introduce whichever one you've decided on, duress by threats or duress of circumstances, and then define. So threats is where you've been forced to commit a crime against your will. And circumstances is where there's not a specific threat from a person, but because of the circumstances you find yourself in. The defence of duress applies to all crimes except murder and attempted murder. And then you can say, so it applies to whatever you've got in your scenario. Commonly in AQA scenarios, it's theft or robbery, but it could be a non-fatal offence. So let's have a look at the first part of the Graham test. And the first part is, did the defendant act in the honest and reasonable belief that they or their family would be seriously injured if they did not comply? And this means that it's a mixture of subjective and objective tests. The defendant must hold an honest belief, that's subjective, that they or their family would be seriously injured, and that belief must be reasonable. So a reasonable person would have to understand why you would think that you or your family would be seriously injured if you didn't comply with the threat. It doesn't matter if, as a matter of fact, the threat can't be carried out. So, for example, if you found out later, if you've been threatened with a gun, but then it was found out that the gun wasn't loaded, that doesn't matter because you would still have an honest and reasonable belief. So remember, in a scenario, it's quite common to not put in whether the defendant's belief was honest and reasonable. And then we're going to go on to look at the specific requirements. So the threat has to be serious, specific, unavoidable, imminent, and not self-induced. So let's have a look at the first one, which is serious. So it has to be an honest and reasonable belief of a threat of death or serious injury. Serious injury is equivalent to really serious harm. And this is a high bar, and it's deliberately set high because for policy reasons, we don't want people to be able to use this defence a lot of the time. In Valderrama Vega, the death threats made against the defendant did qualify, but not financial pressure or the threat to reveal that the defendant was gay. So you need to have a threat of death or serious injury. It can't be of psychological harm either. And these threats have to be made either to the defendant themselves, to their family members, or to people for whom the defendant is responsible. So, for example, passengers in a car that the defendant is driving. And note that the threats can be made indirectly. They don't have to be made directly to the defendant. So let's have a look at specific, what that means. It means that the threat has to tell the defendant what they have to do. It has to be a specific crime, and the defendant must have complied by committing that crime. And this meant that in Cole, where the defendant robbed a building society, the defence was not available. He had been threatened with serious violence by a loan shark if he didn't repay the money he owed, but he was not specifically directed to rob the building society. And this might seem a little bit harsh, but it is to encourage people, again, for policy reasons, to do the right thing, to borrow the money from the bank or a relative or something like that. So, unavoidable. This means that the defendant should not be able to avoid the threat. So you can't use duress if you've got time to inform the police or avoid the crime you've been pressurised into committing. And in the case of Gill, D did have time to go to the police, and so the defence was not available. Next, imminent. The threat was found to be imminent in Hudson and Taylor because the threat was a present threat in the sense that it was effective to neutralise the will of the accused at that time. And that case concerned someone that was giving evidence in a court, and the person who had threatened them was in the public gallery. So whilst the violence couldn't be carried out immediately there and then, it was operating on the defendant's mind as she gave her evidence in court, and the court said that that was sufficient. In the later case of Hassan, in a bid to try and make sure that the law was kept quite tight, the House of Lords, now the Supreme Court, said that it must be able to be carried out immediately or almost immediately, so giving a little bit of leeway there. So if we look at this scenario with Darth Vader, Yoda and Jar Jar Binks on the floor, here the threat, if Darth Vader is threatening Yoda that he has to do something to Jar Jar Binks, otherwise he's going to be seriously injured, the threat is unavoidable as there's no time for Yoda to go to the police because Darth Vader is literally right there. And the threat is imminent. He's right there behind him and he could carry out the threatened violence immediately. In this scenario, Darth Vader is not there. So here the threat might be avoidable, although we don't know for sure, if Yoda has time to go to the police. However, it still could be an imminent threat. It's operating or present because he's thinking about it. The threat is still imminent, even though Darth Vader is not actually there. It is operating or present in Yoda's mind. And this means that you don't need to commit the crime immediately after the threat, which is sometimes a mistake people make in scenarios. And the last thing that you need to consider in part 1 of the Graham test is that the duress should not be self-induced, because if it is self-induced, it will not be available. And this means that self-induced is where the defendant has voluntarily associated with criminals. And this could be that they're in a gang, they're involved with unlawful activity like drug dealing, or they're a member of a banned terrorist organisation, for example. And if that is the case, then the defendant should have reasonably foreseen that they might be forced to commit crimes by threats or violence due to that association. And that is the case of Hassan. However, note that in another case, Shepherd, the defence was available as the gang was not violent. They were just known for stealing rather than violence. Another case you sometimes see mentioned other than Hassan is Sharp in this respect. So that concludes part 1 of the Graham test. Let's have a look at part 2 now. And part 2 of the Graham test asks if a sober person of reasonable firmness sharing the same characteristics would have resisted the threat. And here the law requires you to be neither a hero nor a coward. So what does that mean? Well, according to Bowen, this is what the court can take into account. The age of the defendant, because if you are very old or very young, you may be less able to resist threats. Your sex, which I won't dwell on, but clearly because of the physical characteristics of women, they may be less able to resist threats. Pregnancy, because of the fear for the unborn child. Serious physical disability. And recognised mental illness or psychiatric disorder. That would be more than just being timid or anxious. It actually has to be a recognised mental illness. And in Bowen, they said that this didn't include low IQ. In the Bowen case, the defendant had a reading age of 6. But they said that that could not be taken into account, his low IQ, I think it was 68, because it didn't make him less able to resist threats. The last thing that wouldn't be excluded is voluntarily getting intoxicated either by drink or drugs. So that is the second part, and you need to make sure that you apply it and see if you think that a sober person of reasonable firmness in this situation would have been able to not carry out the crime in response to the threat. And once you've done the Graham test, part 1 and part 2, then you can finish with the effect of the defence, which is acquittal. So it is a good defence if it can be proved, a total acquittal. So we'll just have a quick look at the duress of circumstances defence, which is linked to the common law defence of necessity. You are saying that it was necessary to commit the crime because of the circumstances you found yourself in. And this is often driving offences, for example, speeding or reckless driving, because you're, for example, trying to get someone to hospital, but it applies to the same crimes as duress by threat. So that's everything except murder and attempted murder. And that was confirmed in Pommel, which was a case where the defendant claimed that he was in possession of a prohibited weapon as he was trying to prevent someone else harming someone with it, and that he had intended to give it in to the police that morning. And the Court of Appeal said he should have been allowed to plead duress of circumstances in that situation. The two-part test comes from the case of Martin, and it's almost identical to the Graham test. Was the defendant compelled to act as they did, as they reasonably believed they had good cause to fear that otherwise death or serious injury would result? And the second part, would a sober person of reasonable firmness sharing the same characteristics of the defendant have acted in a similar way? So the only difference is in one, there is no reference to honest and reasonable belief. And so this is a completely objective test. Was their belief in what they did reasonable? It's useful to look at the facts of Martin. The defendant, who was disqualified from driving, drove his stepson to work to avoid him being sacked for lateness, as his wife said that if he didn't do that, that she would commit suicide. She had made previous suicide attempts, so the court said that he should be allowed to plead the defence as a matter of law, but they expressed doubt as to whether a jury would believe what they called an improbable story. But the test still stands. So if you are pleading duress of circumstances, the situation you find yourself in has to be serious, specific and imminent still. So serious means the same, threat of death or serious injury, and as we saw in Martin, it could even include suicide. Specific means in the sense that the defence can be used for any appropriate response to the danger posed by the circumstances. So this even included the hijack of a plane in Abdul Hussein. In Abdul Hussein, the defendants were Shiite Muslims who had fled Iraq for Sudan, and they were under threat of execution if they were returned to Iran, which was becoming increasingly likely as they had overstayed in Sudan. So they hijacked a plane and eventually landed in the UK, where they were charged with the hijack, and they pleaded duress of circumstances, which the Court of Appeal said that they could plead, and they said that this was an appropriate response to the danger posed by the circumstances. They also confirmed in that case that whilst the threat needed to be imminent, it didn't need to be immediate, but imminent in the sense of hanging over them or operating on the defendant's mind at the time. And that is very similar, if you remember, to the case earlier of Hudson and Taylor. It's also likely when you come on to the part 2 that the Bowen factors would apply just as they do in duress by threats. So that's duress of circumstances. And this is a little recap of duress by threats, which, as I said, is the more common defence, the introduction, 2 elements, and the effect of the defence. And a look at the different types of question you might get in an exam. So duress could come up in a multiple choice question. A short answer, which would be a 5 mark, suggests why the defendant may not be able to use the defence of duress, for example. A longer answer, 10-mark question requiring the whole defence to be put in. As part of a theory of law question in question 9, requiring a link to a concept such as justice or fault. Or as part of a 30-mark scenario, as one of the indicative content groups. These are the long questions at the end, 10 and 11. So I'm going to have a look at one of those briefly. This is a scenario from the 2019 AQA A-Level Law exam. So if you need to, pause and have a read through to see what you think needed to be covered in this question. And you can see that the indicative content groups here were robbery, duress, theft and legal advice. Don't forget the 7-mark part about assessing the ways that they might be able to obtain legal advice about their case. And let's just focus, obviously you would have done the offences first and then you would go on to the defence of duress. So let's see what you would say for part 1. So Daryl might have the common law defence of duress by threats, where the defendant has been forced to commit a crime against their will, here by the threat against his son. Duress can apply to all crimes except murder and attempted murder, so may be a defence to robbery. Part 1 of the Graham test must be proved. Here Daryl seems to honestly believe his son will be seriously injured if he did not comply with the threats, as he is told he will end up in hospital. It's hard to know if this is a reasonable belief, as we do not know if the gang are violent. The threat must be specific, which it is here, as he is ordered to steal a laptop computer, and that's what he does. It's unclear whether the threat is unavoidable and whether Daryl had time to go to the police. If it is avoidable, the defence will fail. The threat seems to be imminent in that it is operating on his mind as he takes the laptop, as he, quotes, remembers the earlier threat. However, Daryl may not use the defence if it's self-induced. Here he's a member of a gang and maybe should have foreseen he might be forced to commit crime. However, the gang may not be violent, as they were well known for stealing, and he may not have foreseen this risk. So that's part 1. Then you'd need to do part 2. Would a sober person of reasonable firmness sharing the same characteristics have resisted the threat? And here it's arguable a reasonable man of Daryl's age, whose son has been threatened, might not have been able to resist the threat, and the defence would be available. And if successful, the defence will lead to an acquittal. So that's an example of how to do duress in a scenario, and I hope that the video has been useful. Thank you.